All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today will be a judicial reprimand of Judge Woody Robert Claremont, case number 2025-1319. Judge Claremont. Judge Claremont, we're here today because you and the Judicial Qualifications Commission have agreed that you engaged in certain actions that violated the Code of Judicial Conduct. Specifically, on April 11th, 2025, you acted as defense counsel at a first appearance hearing after a friend had been arrested on a domestic violence charge. You negotiated with the prosecutor handling the case, you provided unsubpoenaed character testimony, and you advocated on your friend's behalf. While there is no evidence that the presiding judge or the prosecutor was influenced by your judicial status, each was aware of that status at the time. You have acknowledged that these actions violated provisions of the Code of Judicial Conduct that prohibit judges from practicing law, from lending the prestige of their judicial office to advance another's private interests, and from engaging in conduct that creates an appearance of impropriety. Judge, your actions showed a remarkable lapse in judgment and risked undermining public confidence in the judiciary of our state. While our court agrees with the Judicial Qualifications Commission that this public reprimand is sufficient discipline, that is largely because of your remorse and your prompt acceptance of responsibility. We urge you from now on to faithfully comply with all the ethical obligations that bind judges in Florida. This concludes your public reprimand, and you are free to leave. Thank you. We will now take up our second case, Costa Benitez versus Angeles Delgado, number 2025-0100.
May it please the court, Mr. Chief Justice. My name is Philip Parrish. Seated to my left is George Gutierrez, trial counsel. We represent the plaintiff petitioner, Julio Benitez, in this case. I can think of no better way to start this oral argument than to quote the late, great Yogi Berra, that this is deja vu all over again. It seems that since 1959, every 15 or 20 years, it's necessary for this court to take up a case and reiterate the ground rules around when it is that a trial court can grant a new trial on the basis that the verdict is against the manifest way of the evidence, and what the role of an appellate court is in reviewing such orders. We're here on conflict jurisdiction because the third district decision conflicts with not only Brown v. Estate of Stuckey, decided in 1999, and Trujillo the next year in 2000, but cases going all the way back to Cloud versus Fallis in 1959, and more recently Van v. Schmidt in 2013. Each of these cases states that it is not necessary in order for a trial judge who is on site and should be given great deference in determining whether a verdict is against the manifest weight of the evidence. It's not necessary that the evidence be clear, obvious, and indisputable in order that the jury was wrong in order to grant a new trial. And
how is a trial judge to know when he or she has sort of transgressed into that other commandment of ours in Brown and elsewhere, that he or she not occupy the jury box? What would an opinion of this court giving guidance to trial court judges look like, given the sort of twin commands in our cases about the role of a trial judge in this posture?
Right, you're referring to the not sitting as a seventh juror line. But this court's opinions have often stated that notwithstanding that command, that when a trial judge, it gives the discretion of the trial judge to rely upon, the language is to rely upon his or her talents and the on-site capacity of what's going on in the courtroom versus, of course, what an appellate court reads in a cold record or what an appellate attorney reads in a cold record who wasn't at trial. I don't know that there's guidance to be given to the trial judge other than that to, trial judges have to have been practicing lawyers for at least 5 years. Most have practiced for much longer than that. They have, this judge has presided over many, many trials, practiced law for a long time. It is, I don't know that there is precise guidance. In this case, one of the rules that's already in this court's case law is that the court may take into account his or her interpretation of a witness's credibility, and that's been clear throughout. In Smith v. Brown in 1978, Stuckey, Castlewood, Van v. Schmidt, they all state that notwithstanding the fact that jurors, of course, get the first crack at credibility determinations in coming to their verdict, that trial judges do have the right, provided that there's a basis in the record. And here there is a basis in the record. It's not often that both experts, including defendant's expert, testified that the plaintiff's testimony about when she first saw Mr. Benitez on his bike could not be correct. To hear her tell the story, it's as if he had been transported from the Starship Enterprise onto the hood of her car. She said, never did I ever see him at all. I felt his impact. In fact, she says, he hit me, I didn't hit him.
It obviously only wasn't limited to expert testimony, though, the evidence presented. And so from the appellate court's perspective, when does a trial court abuse its discretion based on manifest weight? What sort of scenarios? I know it would be no reasonable trial court.
The standard.
But what, from a practical standpoint, what does the evidence look like where a trial court grants a new trial and the appellate court properly applying that standard says that the trial court abused its discretion?
Well, it's easier if the trial court relies on a legal basis and then there's de novo review. There should be few cases where an appellate court reverses an order such as this, because, and modifiers are important. This court's case law says that the trial court has broad discretion in granting these motions and that an appellate court should not reverse except for a clear abuse of discretion. Those modifiers here in this court's case law. I don't know that we can create a specific set of instructions that the trial judge, it's not as if there's some great hue and cry. We're not here because the appellate courts have said, we don't like this standard, we don't know how to apply it, we'd like some discretion, some direction from the Supreme Court. We're here because the 3rd District in this case and other districts have relied upon vestigial authority from pre-Stuckey that applies the wrong standard, and because of mere disagreement. In Castlewood, this court said mere disagreement by an appellate, from an appellate perspective, as to whether the trial judge got the call right is not sufficient. In this case, the panel of the 3rd District, all very good, experienced judges, all trial judges before they were appellate judges, basically said, we disagree. That's not the standard. The standard is, would any reasonable judge grant it? That's a very high standard under any circumstances. And I'm not sure that we ever ask this court to describe precisely what an abuse of discretion means in any given context, because motions for a new trial can be granted on a number of reasons. Now, obviously, if it's a remitter or an editor, we have a statute in place that has certain guidelines that may make it easier. But even so, if it's a non-economic damage award, for instance, you know, this court's authority says that's really very much for the jury. So
well, maybe start back with when a trial judge is considering a motion for new trial, what is the alleged harm that the judge is considering whether to remedy?
I mean, in layman's terms, that the jury got it wrong.
Yes, but what is the right at stake? And before you answer that, tell me, do you think that a party has a right to a particular verdict? Like, if a jury comes back with a verdict, does a party have a right in that verdict?
Well, you have the right to a fair trial. You have the right to. I'm not
That's
certain
where I'm
understanding
headed.
your question.
Well, that's where I'm headed.
Right.
So, you have. I mean, all these cases, there's a right at stake, and in trials, typically the right to a fair trial, whether the trial was fair, and that's typically what's considered on appeal. So we have a motion for a new trial here, and so presumably the movant is claiming that there was something unfair about that. There's something defective about how the jury reached its verdict, right?
Correct.
Okay. So, and the trial court, because it's not a final order, the trial court is making an assessment as to whether, in his or her discretion, it felt like in his or her judgment that there's something wrong, and the judge has to explain it, but they grant a new trial. It's not like there's a judgment entered in the end of that. It's just a new trial.
Correct.
So in the range of discretion that a judge has, what would be outside that discretion and described to the point that it would be arbitrary? When would a decision like that be arbitrary?
Well, I would say when it appears that the judge just simply didn't like the verdict and has no real basis, and I think it's not. It's important to note that in all the cases from this court, the court's stated that the trial judge, even though the jury gets first crack at credibility determinations, the judge, in looking at a motion for a new trial on the basis of that the verdict was against the manifest weight of the evidence, gets to make his or her own credibility determination. And we have bases in the record for this. The one that the testimony, and it was adamant, and it would not give an inch. No, never saw him or the bike at all until there's an impact. Yet, the evidence also shows not a rainy day, about 10 a.m. in the morning, not a lot of traffic, no traffic in front of her, and that the bike is coming from the opposite direction. So, the defense puts a lot of focus on the black pickup truck that's parked to the right, and says, well, she couldn't see the sidewalk that he was coming down. But I would draw the court's attention to page 945 of the record. When she's going south, Mr. Benitez is coming north on this sidewalk. You probably can't see this, but if you look at page 945.
I think this gets into the remand instruction debate. Your friend on the other side has suggested that if we agree with you, the proper remand instruction would be for us to remand to the 3rd District for application of the correct standard, rather than do what I think you're asking us to do right now, which is to weigh the evidence ourselves and then determine whether or not the trial court erred. So what's wrong with that remand, especially if we view remand instructions as the ability to reset where the error occurred? Well,
under this court's authority, actually neither this court nor the 3rd District is supposed to reweigh the evidence. That was for the trial court. I believe I'm responding to the question about, when is it that a trial judge makes this determination, because it doesn't happen very often. It really doesn't, and it happens both for plaintiff or defendant. It doesn't help, one side or the other in the civil cases. The 3rd District is not supposed to reweigh the evidence. They're just supposed to look at it and see whether there is a basis in the record to support the reason given by the trial judge.
In thinking of that, I've been hearing this reasonable man's person
Right.
standard since the first day of law school, and I'm still trying to find it somewhere.
Right.
But I guess the classical case would be like a rear-end collision where you're fully stopped at a traffic light and somebody rear-ends your car and causes damages and injuries. And the jury does not even get the damages, just finds no negligence. That would be the classical, no reasonable person in this world will find that there's no negligence in such a case. If that's the only evidence that was produced. But here, there seems to be some juice in there somewhere. That could she see the guy coming? Could she not see the guy coming? What if instead of just a classical rear-end collision, it happened, you can't get around that, if during cross-examination, the opposing counsel was able to more or less find instances in which a jury will find no negligence?
Well, I think what
Without having to produce
what
any
you're
evidence.
talking about is most trial. We would hope any case that goes to a jury, there were facts on either side. Otherwise, there should be a directed verdict, right? So every case that goes to verdict and there is a grant of new trial on the basis of being against the manifest way of the verdict had some evidence going both ways, or else it should not have gone to the jury in the first place. There has been no, delineation of in what specific circumstances, because there could be any number of reasons. We rely on, and this court's authority says we rely upon the trial court who's there. And keep in mind, trial judges don't want to willy-nilly grant motions for new trial. That's more work for them. They have to, that's a non-legal basis for them not to do it. But and I don't think that this court has seen, there's been no empirical evidence that trial judges are profligately granting motions for a new trial on the basis that the verdict is against the manifest way of the evidence. I think Judge Lopez in this case, took his job seriously and believed that based upon the facts in this case, and with the defense expert clearly stating that the defendant's testimony had to be incorrect, and with there being the other evidence was he also agreed, the defense expert, that the bike was already halfway across the street when the impact occurred. Again, that doesn't jive with reality that there's no liability on the part of the defendant.
I mean, at the end of the day, doesn't it, from the appellate court's perspective, it seems like they have to look at two things. One, does the trial court's explanation show that it understood the legal test correctly? And so if you have a court that seems to think that, hey, if there's any evidence on one side in favor of the verdict, then my hands are tied. And then you look at the actual evidence to make sure that whatever reasons that presumably, if you get to this point, would have been consistent with the legal test, as long as there's actual evidence in the record that sort of backs up what the reasons. A court could give reasons that sound plausible, but then if you actually look at the record, maybe it's not backed up. So, I mean, it seems like if you sort of check both of those boxes, then there should be a lot of deference given to what the trial court
Absolutely,
does.
that's what this court said in Van v. Schmidt, that it's the trial judge who makes the call, and the reviewing court, whether it's the Intermediate District Court of Appeal or even this court, does not reweigh the evidence. It just sort of checks the trial court's work. You can't just make it up as the trial court judge. You have to be able to point to something. And here, the order points to the fact that both the experts agreed that the plaintiff's testimony lacked credibility, and credibility is one of the factors mentioned in Stuckey, in all of the court's cases for why, and it allows the trial court judge to do that, provided there's a basis for it, and there is a clear basis for it in this case. And
that's the other part of my question. So we talked about I was asking about the harm that the trial judge might be correcting through granting a motion for a new trial. On appeal, isn't the appellate court reviewing just to ensure a party's right against arbitrary decisions of the trial court. So when we have an abuse of discretion standard, it's just making sure the trial judge didn't act arbitrarily, and as the chief was just asking, if you check those two boxes, it sounds like that is not arbitrary, and then the appellate court should just affirm at that point.
Absolutely, that's what this court said in Van de Schmidt and its prior cases. And I think that's where the third district got it wrong in this case. And so I don't think there's a basis to remand because they can't reweigh the evidence. This court can see for itself, just as well as the third district, whether there is a basis. I suggest that there is a basis, and therefore that the trial court did not abuse its broad discretion, and there's no clear abuse of discretion, and therefore this court should reverse the third district and remand for re-entry of the new trial order so that the case can be tried again. If there are no further questions, I'll save my remaining argument for rebuttal.
Thank you.
Thank you.
Good morning. May it please the court. Kevin Franz on behalf of the respondents. This court should affirm because the trial court did abuse its discretion and the third district correctly reversed. The reason is because the trial court's reasoning was not supported by the record. And the lone sentence, the clear, obvious, and indisputable, in this case can either be partly receded from or modified to harmonize it with Stuckey. The standard of abuse of discretion, Van versus Schmidt, explains it to us, and it recognized that there's an abuse if the evidence in the record does not support the trial court's reasoning for granting the new trial.
We should start with the standard, though, first, because abuse of discretion would be the appellate court's standard of review and reviewing whether or not the trial court properly applied its standard, which would be manifest weight of the evidence or whatever you think we should recede.
Correct, Your Honor. So the standard for the appellate court is abuse of discretion. So the question is, what does abuse of discretion mean? We know that it means no reasonable person would agree with what the judge said, but this court in Van versus Schmidt said one example is if, in this particular case, in terms of a new trial for manifest weight, is if the evidence in the record does not support the trial court's determination. And that is exactly what happened here.
But I think the question is asking you to focus on the first step. So the first step is what is the test that forget about the standard of review for the appellate court. What is the trial court supposed to be asking? That's kind of step one. And then step two is, given whatever its analysis was their characterization of the record correct? And so do you agree that the standard of is there evidence in the record that could support the verdict? Do you agree that that's an incorrect standard?
I do agree with that.
Okay.
Yes.
So what is the correct standard? Give us your affirmative statement of what the correct standard is.
Well, I think that there has to be, essentially, the verdict has to be against all of the evidence that cannot be interpreted in the way that the jury somehow rendered a verdict for.
And not DV, though?
Well, I think that you have to have reasoning that is supported by the evidence, and that's what is lacking here. To tell you the truth, I'm not sure why a trial judge should be able to be a super juror or decide that, well, I know they got it wrong, so I'm just going to change it.
Well,
but there has to be
different, right? Though it's not a directed verdict.
Right.
It's a new trial, so it's a do-over. But it's not exactly that he's replacing the role of a juror. He's just sort of saying we're going to give it another shot because I think something went wrong. But I guess kind of following up with what Justice Sasso said, are you indicating that it would not be appropriate for the trial judge to look at credibility of witnesses or consider that at all? Because, I mean, that's not going to be necessarily clear from just reading a record and looking at evidence.
Correct. The trial court absolutely has the right to look at credibility. That's what Stuckey says. But I would like to quote from this court in Van versus Schmidt that said, but said, but the closer an issue comes to being purely legal in nature, the less discretion a trial court enjoys in ruling on a new motion new motion for new trial. This discretion is significantly reduced when the motion concerns a purely legal question. That is so because the error involving the purely legal question can be accurately reviewed from the appellate record. And that's what I asked this court to do, because in this case, the reasoning given by the trial court is not supported by the record. And I want to make 2 points. In the new trial order, the court wrote, based on defendant's own expert, Michael J. Urban, who on cross-examination conceded that Ms. Carrillo had to see the plaintiff in time to stop her vehicle. You will not find that in the record. He never testified, ever, that she had time to stop her vehicle. The record, his cross-examination is pages 1373 to 1411. He never testified that she had time to avoid the accident. He testified the exact opposite, that she could not have avoided the accident. So that is the first problem with the trial judge's ruling, that the reasoning is completely contradicted by the record. And the second problem is that the trial court made a decision, essentially a decision of law that was adverse to Florida law. And that's when the court said, contrary to all expert testimony, defendant driver testified that she did not see plaintiff until he was on the hood of her car. This called into question the credibility of the defendant. The manifest way of the evidence established at least some responsibility on the defendant driver. That reasoning is an abuse of discretion because it violates Florida law. Under Florida law, negligence is simply the failure to use reasonable care under the circumstances. The evidence in this case from my client's expert was that he saw her a quarter of a second, a snap of a finger, before the impact. That does not, just seeing someone before an impact does not equal negligence as a matter of law. The question is, was it reasonable? Could she have done anything different to avoid the accident? And the testimony from our expert is that she could not perceive and react in time to avoid the accident. So what the trial court did was say, look, I'm judging the credibility. She saw him. You know, maybe she saw him a second before, maybe she saw him a quarter of a second before, but guess what? That equals negligence. But that is not what Florida law is, and as I mentioned in Van versus Schmidt, the closer you come to an issue of law, the less discretion that the trial court has. And I think that a case that is directly on point here is Valenti versus Sareva from the Florida 2nd DCA in 2020. In that case, Valenti switched lanes on a highway and hit a motorcycle driven by Sareva. The jury found no negligence on behalf of Valenti. The trial court granted a new trial based on the manifest weight of the evidence and said, look, Valenti caused the accident by switching lanes, so there's got to be some responsibility. The 2nd DCA reversed, and the reason it reversed is because the reasons for granting a new trial, finding at least some undisputed liability, was not supported by the record. It said changing lanes alone doesn't say anything about whether the conduct in doing so was negligent. The question is whether a reasonably careful person would have done that in similar circumstances. His actions by itself doesn't make it undisputed that he failed to exercise reasonable care, and as we know, the mere occurrence of an accident doesn't give rise to an inference of negligence. So simply put, and this is from Van versus Schmidt, if the record does not support the trial court's reasoning, that's an abuse. And it does not in this case.
So do you think it's an abuse of discretion even under the manifest weight of the evidence standard, or do you think that in order for us to decide in your client's favor, we would need to apply a different standard, just go under this abuse of discretion concept?
No, I think that, so a trial court abuses its discretion in granting a motion for new trial based on manifest weight of the evidence if it abuses its discretion. And what is abuse of discretion? One example is if the record does not support what the trial court's reasoning is. In other words, no reasonable judge in looking at this this evidence could agree with what the trial court did. So that would be the abuse of discretion. And I would, obviously the problematic language, we have the clear, obvious, and undisputable language. I think that this court can, and certainly not quash, and maybe either recede in part just from that one sentence or modify it. I think it's important to look at Justice Pariente's dissent in Stuckey. And she said, I would affirm, first, there's no conflict with Cloud, which addresses that the appellate standard of review is an abuse of discretion, but does not elaborate on the trial court's standard for determining what constitutes manifest weight of the evidence. I think that goes back to your first question. What exactly is the trial court supposed to look at? Justice Pariente didn't know. I don't really know, but I just looked up the definition of what manifest means, and it's kind of problematic. Manifest literally is defined in Black's Law Dictionary as clear, obvious, and unquestionable. So if the language that we're saying is a problem is clear, obvious, and indisputable, yet that's exactly the definition of manifest, what do we do with that? So I think that there's a couple ways that the court can look at this. One way is to affirm the DCA because it correctly ruled that there was an abuse of discretion because the record is not supported by the reasoning, or the reasoning is not supported by the record, but clarified that manifest just is defined as clear, obvious, and indisputable. So just using those words in these cases doesn't mean that it's contrary to law. It means that that's the definition of manifest. But this court could reiterate that a district court of appeal cannot reverse an order granting a new trial based only on the DCA's opinion that the evidence was not clear, obvious, and indisputable. And there's a relatively new case from the third DCA, Corzo versus Montero, 406 Southern 3rd 281 from 2025, that I think this court can use in terms of maybe giving some more guidance.
Is that one in your brief?
It is not, Your Honor.
Okay.
I apologize.
What do you think our role is? You're saying a lot of what we could do, and what is the route? What are we trying to accomplish? And okay, let me put it this way: why would we not look back at the common law tradition of manifest weight of the evidence that apparently Florida has adopted since very early on, and give meaning to the manifest weight of the evidence based on that common law tradition, rather than trying right now to kind of merge all these cases that you're talking about into something that fits what you think it should be? I mean, what are we doing?
Well, I mean, if you look back at the cases discussing manifest weight of the evidence, there's a lot of language used that is not a clear, simple sentence in terms of giving guidance to the trial court. I mean, we know that the trial court can exercise its judgment in reviewing the credibility of witnesses, but when does that cross over into an abuse of discretion? I think that the answer, actually, the petitioner relied on this case. Hashmi Alikhon said, hey, that's the right thing to do. And this case, Corzo, that I was mentioning, I think, which actually cites to Hashmi, I think gives maybe the best idea that I can come up with for this court, which is to say, and this, what I'm about to quote, cites to and quotes Stuckey, the Wackenhut decision from this court in 1978, the Valenti case that I mentioned earlier, and this Hashmi case. And it says, we review, and this is for an appellate court reviewing and to figure out what exactly do we look at to determine whether there is an abuse of discretion. And the court says, we review an order granting a motion for new trial for an abuse of discretion. Nevertheless, a trial court's discretion in this regard is not unbridled or limitless. In other words, the trial court does not sit as a seventh juror with veto power. He or she is not a super juror overriding the will of the jury. In fact, and this I think is the critical point, the reasons set forth in the order must be supported by the record. If not, the trial court abuses its discretion. I think that's what this comes down to, at least in terms of the appellate review. And in terms of this case, as I've explained, simply put, the reasons that the trial court gave in this case for taking this verdict away from the jury, which is sacrosanct, and I understand Your Honor's position that, well, we're going to get a new trial, but the jury is supposed to be the end of this. Whatever the jury decides is supposed to be the end. So to take it away from the jury, you have to, your rationale has to be completely consistent with what the evidence is. We shouldn't be able to poke holes in that. And as I've explained, not only did the court get the facts wrong about what the expert said, but the court basically found that, well, She saw him for a quarter of a second, so she at least bears some responsibility, and that is simply not the law in Florida.
Well, maybe instead, I mean, the trial judge is there. He's heard all the evidence. He's sat through the entire trial. He understands how voir dire went. He knows about this jury. He knows, I mean, because he was there. And he hears all of it, and then there's obviously a dispute as to whether she was speeding. And it seems like, okay, she's saying that she didn't see him until he was on the hood until the plaintiff was on the hood of her car, which maybe in his mind he's also thinking, well, okay, then that also sounds like she was there. How did she not see him until he was on the hood of her car? Maybe she was then speeding. So there seems to be something up in the trial that he was concerned about, that this jury just. If the right is you have a right to an impartial jury and a fair trial, and the judge has suspicions that there's something else going on with this jury, that they weren't totally impartial, they didn't properly hear all the evidence and weigh it and do all the things that we expect a jury to do, and his concern, like the safety valve is saying, okay, let's just do a new trial, and let's have it done right, And the benefit of a new trial is now the lawyers have. The lawyers and the judge have more knowledge about the case, or more familiar with the facts and the law, and so there's not as many surprises, and so it would be an orderly proceeding for the second trial. What is arbitrary about what the trial judge did here?
If every many accidents, I won't say most, are bang bang, this is literally a quarter of a second. So if every accident where somebody, and it's tough to tell whether in a quarter of a second, milliseconds, what happened first. Did you see them, or did they hit your car first? If we have every case where a trial judge is going to say, well, she saw him at least less than a second beforehand, we cannot have a verdict finding no negligence, then that is getting rid of essentially the jury system. The jury has the right to determine whether, and quite frankly, it doesn't matter whether she saw him, a second, a quarter of a second. The question is, could she have avoided the accident? And the expert in this case said a reasonable person under the exact circumstances in this case could not have avoided it. And the reason that we have a clear abuse of discretion in this case is because the trial judge got the facts wrong, saying that their expert said that she could have avoided it when he absolutely did not say that.
And what did you mentioned that the trial court got it wrong, and you cited pages 1373 to 1411 of the record that involve a cross-examination of her witness, who the trial court says admitted on cross-examination that she had to have seen him. So if that is wrong, what did the testimony actually say?
He admitted that he had to have seen him, but he did
admit under cross-examination
that she saw him,
that she did see him,
but he did not admit that she had enough time to stop, and that is the critical testimony. Because if you're in an accident, let's say you cause an accident and you see someone, but there is no humanly possible way for you to avoid it, because in this case a bicycle just came right into the lane, that a jury can certainly find that you acted reasonably under the circumstances. In fact, you couldn't do anything. And here's his testimony. This is on page 1371. And in your expert opinion, with the perception reaction time, with the truck parked where it is, with your speed calculations and the calculations of the bicycle, would my client be able to avoid this impact? No. Everything, the speed of the bicycle, the speed of her car, and her perception response time, everything landed right within her perception response time, was right within the average perception response of an average individual. And then he was asked, after reviewing all of the evidence, what is your opinion? My opinion was that there was no way to avoid this accident. She had perceived and reacted as an average person would have traveling at the posted speed limit or under. So, and Your Honor, I apologize if I misspoke, but the evidence is that she saw him. The expert testimony that she saw him milliseconds, or a quarter of a second before accident, but he never said, it is my opinion that she somehow could have avoided this accident. So for those reasons, we would ask that this court affirm the DCA's opinion because it correctly held that the trial court abused its discretion in granting a new trial.
Is there anything to be read into the fact that the judge initially entered an unelaborated order and it took a motion for reconsideration to get explanation for it?
I think
is it all suggestive? I mean, should we consider that at all? Is that indicative of he didn't have a reason, or he came up with, I don't know.
Well, I mean, what's also interesting to that point is the judge, he denied a motion for directed verdict, which basically means no reasonable jury could find the defendant non-negligent. So I think it's unclear why you would deny a motion for directed verdict on liability, but then grant a motion for new trial and manifest weight. As for the motion for reconsideration, the first order violated Florida law because it did not provide the reasons why. And then unfortunately what happened, the reasons that were given are clearly contradictory to the record. Thank you for your time.
Thank you.
Let me pick up first, Justice Tannenbaum, with your question about the unelaborated order. That was an order, there was a hearing where the bases for the motion for new trial were discussed, and it was not that their expert testified she had time to stop. It was that he testified that there was, that her testimony about not seeing him until the impact was incorrect. The trial counsel submitted an unelaborated order to the trial court after he asked for both sides to submit. I got involved in the case after the notice of appeal was filed. Defense counsel filed a motion to relinquish jurisdiction. I did not oppose it except on the merits and said that's right, we have to go back and get an elaborated order, at which time there's a second hearing. And again, it's argued not as the judge says in that one sentence, but as we argued to the judge, as we argued to the third district, as the third district stated in its opinion, and as we argued to this court, simply that the expert testified that she was not credible in terms of not seeing the bicycle. Quite frankly, I mean, I think that is a misstatement by the judge. Would concede that. We've not argued that to the third district. The third district's opinion says the trial court had concerns regarding Carrillo's testimony that she did not see Benitez before hitting him when both parties' experts stated that she had to have seen him due to her braking before impact. Nobody in this case, and I think that's just I think what the judge meant to say was that the expert agreed that she had time to apply her brakes, and he simply misstated it. He did write the second order. But
what about the fact that you're looking at the evidence, your opposing counsel has pointed out, but the trial judge seems to be weighing the evidence, that there's evidence that, okay, she saw him, but there's conflicting testimonies of whether she could have stopped. Why? How does that end up being manifest weight of the evidence contrary to the verdict at that point?
Well, let me first start with saying that their experts said she had a quarter of a second. Our experts said she had up to 2.9, right. Almost 3 seconds.
That's a dispute.
Right, yes, of course it is. And you're entitled, a judge is entitled to grant a new trial on the basis of manifest weight of the evidence, even though the testimony was disputed. In fact, as I stated earlier, obviously, in order to grant a new trial, there has to, the case has to reach a jury. There has to be conflicts in the testimony for that to occur. But the basis is, in paragraph 9 of the court's opinion, contrary to all expert testimony, defendant driver testified that she did not see plaintiff until he was on the hood of her car after being struck by the front of her car. This testimony called into question the credibility of the defendant. And then he concludes the manifest weight of the evidence established at least some responsibility on the defendant. I think if the jury had said, yes, defendant's liable, and you pick the percentage of whether it was 10% on the plaintiff or 90% on the plaintiff or something in between, I don't think we're here. The evidence, and again, it's the fact that she'd had to have seen him before impact, the fact that his bike is halfway across the road and perpendicular to her vehicle. Again, it didn't just appear out of thin air. And keep in mind, the defendant was a TV personality on Spanish language TV in Miami. I think a lot of the jurors, knew who she was. That might have, whether that went into the equation, we don't know. We know that the jury was, arguing 4 hours over one question on a 2.5-day trial. In a case where the defense didn't really put on any damages witnesses, they just cross-examined our damages witnesses. So, the judge relied on his talents, his observations, his credibility determination, and I think that Mr. Franz, I credit him for picking up one, misstatement that, quite frankly, we never relied on. I think it is wrong, and I don't think that's the basis of the grant of the new trial.
Counsel, I'm sorry to interrupt you. You can have 30 seconds to finish up.
Nor did the third district. The third district decided the case on the basis that we argued to it, and that all parties argued to it, that it was the lack of credibility due to the defense expert saying that she had to have seen him, and the other evidence that she had to have seen him, and there had to have been some liability on the part of the defendant. And again, this is not a pure legal issue. It's an intensely factual determination. We'd ask the court to reverse the third district and remand for reinstatement of the new trial order. Thank you.
Thank you very much. Okay, we'll now take up our next case, Eglin Federal Credit Union versus Baird, number 2025-0221. Whenever you're ready.
Thank you. Good morning, Your Honors. James Brannett and Mike Chesser on behalf of the Eglin Federal Credit Union. May it please the court. We are here today because the First District Court of Appeals came up out of whole cloth with an entirely new rule about how to interpret arbitration agreements that no court has previously used and no court has since followed. And in fact, what the First District did here is contrary to both this court and the Court of Appeals rulings about the meaning of the word any, and that is enough to establish that a arbitration provision will apply retroactively. In addition, the sole case relied on by the First District, the All South case, did not actually support the First District's decision here, and in fact, the First District actually misinterpreted that case. Here, what the First District said is that the All South ruling was, quote, because the language of the new arbitration agreement was not retroactive, it wouldn't apply the terms and conditions sent in 2012. However, the court in First District actually never said there was a new agreement. In fact, they said there was no agreement. There was no new agreement. There was a 2010 agreement, an invoice actually, without any terms and conditions, which did not mention arbitration. And the dispute that the defendant, AmeriGas, was trying to use involved solely that 2010 invoice. Sometime in 2012, AmeriGas sent out just terms and conditions, not a new contract, but just terms and conditions. At that time, though, the plaintiff, AllSouth, was not involved with AmeriGas at all. There were no pending contracts. There were no pending relationship. They were strangers to each other. So what the court in AllSouth found was, you send out a mailer, a bulk mailing to all of your customers. That doesn't mean you now have new contract terms with all of your customers. And that's supported by the language in actually the very page cited by our first district as the holding. It says the resolution of the issue before the court in the AllSouth case rests on the first prong of the Seifert test, whether a valid written agreement to arbitrate was shown to exist. In other words, did the 2012 bulk mailing constitute an agreement to arbitrate? And they said the very existence of an agreement at page 86 to arbitrate is what is at issue here. Is there an agreement to arbitrate? And their answer is that the AllSouth's mere receipt of the bulk mailer in 2012 did not evidence assent to a new contract. That's all that happened. They got something in the mail. You know, the holding in AllSouth would have been a lot clearer to everybody, including our court, if they had used two words: junk mail. Junk mail. The 2012 bulk mailer was junk mail. You get something in the mail all the time.
What about the word spam? Isn't what your client did? Isn't what your client? Well, but isn't what your client did arguably spam?
No, Your Honor, that's no.
Tell me. You put quite a bit of weight. Let's talk about notice for 1 second, because the individuals are in slightly different positions with respect to notice.
Yeah.
Can we talk about your proposed understanding of the words "read more" in an email? You say that the emails instructed read more. I don't think that's a fair reading or a common reading of read more in an email forward. It gives me the option to read more if I choose to, but a lot of the contractual terms that are relevant to your position today are hiding behind a couple steps, affirmative steps by the spam recipient, by the email recipient, who may not know, in the way that I grant you, someone who receives a notice by mail, and it clearly says, look, we have an ongoing relationship. Your continuation of that ongoing relationship is subject to these additional terms. Okay, I understand your argument. I think would you agree at least that you're in a slightly more thin ice position with respect to the person who has to take affirmative steps upon receipt of an email message to see that there's been an alteration in the contractual terms of the agreement?
Right. What you're talking about, that situation applied only to Beard, obviously.
Right.
And in that case, for Beard, we are relying on the inquiry notice or constructive notice. We're also, though, relying on an inference of the actual events that were shown, which is that she routinely went on the website, and on the date she received this notice, she went on the website 5 times.
A fortunate fact for you.
Yeah.
But I'm curious about the rule you'd have us adopt, and whether putting behind a hypertext link and then some, because it isn't just like I click on this link and I go to the terms and conditions. It was a little bit more that I had to do to actually see that my deal with you was changing. Can you answer, leaving aside the fact that this particular user was a frequent, online banker or whatever, let's stipulate that. Is the rule you want us to adopt that it is sufficient for an amendment, a meaningful change in the contractual agreement, for there to be an email that says, hey, read more, and then all the term changes are behind the read more?
No, not on its own, not on its own.
Okay.
What we're asking for is that the additional facts, though, do show enough of an inference that she may have had actual knowledge, not just from the notice, but from actually going and seeing and getting a copy of the new provision. And that's why we ask for, as part of the relief here, is that it be remanded as to her for an evidentiary hearing. Because if there's an issue of fact, then that's what's required before you make a ruling as to whether she received notice of this arbitration demand or arbitration agreement. So that would be one of the keys. In fact, I know this isn't a record, but there is something unique about Beard that I think may come out, and if it does get back for evidentiary.
So for purposes of her, you're not even asking that we find that she's subject to arbitration, just remand for an evidentiary hearing. That's your position today.
I think that's the most appropriate resolution as to Beard, yes.
And we could, go ahead. So we could reject your argument on inquiry notice and just send it back for a hearing on actual notice?
Well,
I know you don't want us to reject your position on inquiry notice, but I mean, I think that it would be a big deal precedent-wise and maybe ill-advised. It may be just wrong legally to suggest that, you know, that there was enough here to trigger inquiry notice. But if you're, you know, if there's a possibility that she actually saw the agreement, you know, because of these unique facts here or whatever, that's obviously a completely different issue.
Well, we've thrown out the argument that there was constructive or inquiry notice, and I concede there's no case law directly on point that what we actually sent to her, if all you do is view that in isolation, that is enough to say that she actually has notice or she has the legal notice and has assented. So that's why I say I think the most appropriate resolution as to Beard alone is that it be remanded for an evidentiary hearing based on the fact that we raised enough facts to raise an inference that she had actual knowledge of the existence of it and may have even read it.
Counsel, I have a question. A question regarding jurisdiction as to Baird. So this is here on conflict. The conflict has to do with the retroactivity, and the retroactivity was applied only to, sorry, I just forgot the other name, but the
Stokes.
Thank you, Stokes. Do you agree? I mean, so retroactivity didn't come up at all with respect to Baird. It was just the first DCA. Well, let me back up. So there's actually two motions to compel. One applied to each plaintiff. There were originally two distinct plaintiffs, and it was consolidated eventually. But there's still two different plaintiffs, have two different positions, two different motions apply, and each applied to them, you know, under their circumstances. And it seems like you actually acknowledge that because you're asking for an evidentiary hearing as to Baird. So in theory, the first DCA could have had two appeals and considered the Baird, the order regarding Baird in one appeal and the order regarding Stokes in the other. And had that happened, then we wouldn't even be here regarding Baird because there wouldn't have been conflict. Why then is it necessary for us to reach the question regarding Baird to just address the retroactivity, the conflict question regarding retroactivity? How does that save anyone any time? Because we could just approve or not even reach the first DCA's decision regarding Baird, just address Stokes and then send it back. It doesn't save any time, in other words, to address the separate question regarding Baird, which is not your on conflict.
Well, it did. I mean, the first district did raise retroactivity as an alternative basis for affirming the dismissal, the denial of our motion to compel arbitration for Baird as well. So the first district did apply.
Right, but it
as
wouldn't
well as
change anything. Even if we disagree with the first regarding retroactivity, it would have zero effect on Baird because the first DCA is already affirmed on the basis that there wasn't an arbitration agreement to begin with. So why do we need to reach out? I mean, it's kind of like a free hit for you on an order that, but for the conflict on retroactivity, you would never have gotten here in the first place, and you would have been done on that.
Well, I mean, but all I'm thinking is that it's within this court's jurisdiction to address all the issues raised by the Court of Appeals when it accepts the appeal. Even though it's due to a conflict, it still would, it's within the court's jurisdiction and discretion to address the additional issues.
Well, typically that is in connection with when we have to make a decision on something. We have to reach the decision of the first DCA in this case, and so if this were wrapped up in it, that would make more sense. But this is an unusual instance where you actually have two separate orders. I mean, it was one consolidated order, but it was actually an order denying two separate motions. And in realistic, logistically, it could have been two separate appeals. It's just by, and so the approach that you're suggesting, doesn't it encourage DCAs to, they should segregate their appeals and then, you know, save from review from this court those things that have nothing to do with.
I don't know that it could do that because the two cases were consolidated in the trial court before it ever went up. There was only one appeal.
Well, that's fine. You can have multiple appeals in the same case. I mean, you have two different plaintiffs, and, you know, in theory, the defendant could have filed a notice of appeal to each of them, and the rule would have allowed for those to be considered together. But they are two different appeals because they are two different orders applying to two different plaintiffs.
I may be mistaken, Your Honor, but I think it was one order from the
Counsel,
trial.
I'm sorry. I'm sorry to cut you off. I have a question about what. So the remedy you're asking this court to do is essentially send it back for an evidentiary hearing on Beard, and then as to Stokes, what's the ask?
The ask is to reverse the Court of Appeals.
Okay. And what's your strongest argument for reversing the Court of Appeals on Stokes?
Well, to answer the idea of junk mail, in All South does not support the First District's opinion because he gets this thing in the mail. They have nothing going on.
So All South is based on a single transaction, so you find it distinguishable. I think, is that the argument?
Yeah, I mean, it's not only distinguishable, but it doesn't even stand for the proposition that the First District tried to make it stand for.
And so what is your strongest case for reversing as to Stokes?
The strongest case is based on the fact that the First District's ruling that it needs to be unambiguous that it applies retroactively, specifically.
How do you distinguish this from that proposition from Clay, the 11th Circuit case?
In Clay, it was a separate, entirely separate agreement. In other words, there was nothing. The two different cases, there were two different contracts at issue in that case, and one had nothing to do with the other. In this case, unlike even in All South, this is one contract. They had to sign on to the contract when they joined the credit union. They had to, and when they did, they agreed they would abide by all amendments thereafter. And that's exactly what this is. This is an amendment to the same contract.
So what's wrong with Clay's, is there something wrong with Clay's proposition of law that essentially you can't arbitrate claims that accrued prior to the existence of an arbitration agreement because it's just standard contract law? Arbitration agreements, like any other agreement, goes by standard contract law, and those claims that occurred when a contract didn't exist don't fall within the agreement. Do you think there's something wrong with that proposition of law, or is it just based on the any claims language of this agreement? It clearly reaches back.
Well, it's based on both. I mean, in Clay, that there was the second contract specifically said this begins to be effective on a specific date. We don't have that here. Mm-hmm. And second, it didn't have the same language that we have in this case, where as this court and all the courts across the country have held, is all-encompassing, and that that word is a very powerful word all by itself because it is all-encompassing and it applies retroactively, prospectively.
Do you think that is this a situation where talking in terms of retroactivity is just sort of off the mark anyway, since the claim was filed after the? Yeah. You know, I mean, is that we've said similar? We've used that sort of analysis, like in the Love case you're probably familiar with, where you're talking about procedural rules and stuff. I mean, would it be even just kind of a category error to even be thinking about this in terms of retroactivity at all?
I believe so, Your Honor, and part of that, actually, the plaintiffs pointed out in their response brief in the Johnson versus Heartland case that it talks about any dispute. Any claims and any dispute or controversy. And the court there said, well, yeah, the events happened before, but the claim was filed later. And so it is applying prospectively, and that's exactly what happened here. They accepted the arbitration agreement. It was then binding on them, and then at that point they filed suit after. So it was applying prospectively according to that precedent.
Would it be any different in consideration had Barrett or Stokes filed suit first and then Eglin sent out, the amendment to the arbitration agreement?
Yeah, I mean, there definitely would be other considerations to take. I think that we could still make the case that it was valid as long as we showed that they assented to it and its terms, which include any, which, as this court and all the others across the country have held, is all-encompassing.
Then that would definitely pose a retroactivity question.
Yes, that would. I think also the reason that Dole South or the First District's opinion is wrong is because it's also directly contrary to the requirements of the FAA. Under the Federal Arbitration Act, you cannot impose special requirements on arbitration agreements. And that's exactly what they did here. They said, for arbitration agreements, we're going to require that you unequivocally state that it applies retroactively, notwithstanding the use of any. But that's not that. The key point here is that the First District, in our case, excised and did not consider that word any at all. It didn't. It didn't even include it in its quote of what is arbitrable under the provision. It blipped over that word altogether. Consequently, it has absolutely added an entirely new requirement solely for arbitration agreements. As all the cases point out, this isn't required that we say that it applies retroactively. When we use the word any, that's enough to show that it does on all other types of contract. Now we have a new agreement solely for for arbitration that requires some kind of special phrase. That's exactly what the Supreme Court, U.S. Supreme Court, and all the other federal courts and all the state courts that have applied the FAA said is not allowed.
Hey, I'm sorry to interrupt you, but you're going to be out of your rebuttal time.
Okay, you're saying I'm approaching 17 minutes, right?
I mean, that's all of your time total.
Your Honor.
Yeah.
I'll save the rest for rebuttal. Thank you, Your Honor.
Thanks.
If it may please the court, Robert Price from Pensacola, Florida, here on behalf of the respondents. I'll start off, I think there's three big issues here. The court addressed the first one, and what the court said, I was thinking similarly when I was getting ready here. It doesn't seem like there's much of a dispute as to Ms. Bayard and the fact that there appears to be no evidence in the record that this case is like any other case out there, meaning that she received an email. The email said nothing about a change in provisions, had a link to it, that if you followed the link, you'd get to the junk mail, the spam, that you would then have to search further to try to figure out if there was something really important happening here. I personally get those from ECUA and places like that. I don't read them. It's junk mail.
Why should we reject what he's saying about the need for a hearing on actual notice?
The need for a hearing on actual notice. I think
for Bayard in particular.
For Bayard in particular, I think that the circumstances here are clean enough and clear enough legally that people that received an email, I think the law to me is pretty clear.
That she actually went and saw on the website, the actual notice thing isn't dependent on the email part. It's saying she went on the site, she saw that's obviously he wants a hearing on it. I mean, that's the question.
Right. And there was a discovery conducted on that by Ms. Stanton. She was deposed for several hours, and she was asked those questions, and she was unable at the deposition to confirm that. She was asked those questions specifically, and from my recollection of the record, she was not able. It doesn't appear as if their system was adequately able to capture that.
I'm sorry, but was this raised to the first DCA, this request for a hearing on actual notice?
I don't believe it was. That's not something we've asked for. We think the record's clear, but
Right,
yeah,
but the other side didn't raise this issue at the first and request a hearing?
To the best of my knowledge, this is the first I'm hearing of it today, that we're going to come in here today and talk about more facts that need to be developed. I think the facts, at least to Baird and those people that received the email, are pretty clear. And Ms. Stanton was deposed on it. And from my reading of the Stanton deposition, which I read last night in my hotel room, is that she was asked several questions about their system's ability to track those things. And the best thing that she could say is that Ms. Baird and Ms. Stokes, I believe, visited the website numerous times. And of course, that's Eglyn's argument as to some assent, right? Which, the one thing that's also missing that is present in other cases is that there are plenty of places on a website or on a phone app to have a banner or something like that that's very conspicuous to people that go on the website. But there's no evidence of that here. It was a case where this was really buried in multiple layers, which is what the trial court said and what the first DCA properly said.
Okay, so that's issue one. What are the next two?
Right. So the other issues, I'll start and then maybe want to end on something, which is this, what's called the poison pill clause. So, what that is to me, and my dad was a businessman, what that is that you here in Florida, contract law and just principles of business say that you have to reach your hand out and say, here's your offer. And you have to give the person some amount of time, even a millisecond, to put their hand back out and say, I accept your offer. So on the poison pill clause, which is something that will actually annihilate the arbitration clause by the terms of Eglyn's own agreement, under the poison pill clause, if what they did is improper and against the law, which it is, under Florida law, you cannot say to someone, I've already done something to you. That is not something that you can say to someone and have a valid contract.
Well, your friends have one argument in response. So if we may, I'd like to shift just a little bit to federal arbitration law for a second.
Okay.
So first, you'd agree that the agreement provides that disputes are going to be settled under the rules of the American Arbitration Association, AAA rules, right? We agree that that's what it provides. Okay. Page 26 of their brief, they argue that Rule 14A of the AAA rules provides quote, the arbitrator shall have the power to rule on his or her own jurisdiction, including any objections with respect to the existence, scope, or validity of the arbitration agreement, or to the arbitrability of any claim or counterclaim. So the answer to your poison pill argument, or at least one of the arguments from the other side about your poison pill argument, is you're saying that the existence of that contract is a nullity under Florida law because there's no meeting of the minds, there's no offer and acceptance. But federal arbitration law provides pretty clearly that whether you're right or wrong, that's a question to be decided by the arbitrator in the first instance. That's what the provision is. Debates even about the existence of an arbitration contract are to be arbitrated. What's your answer to that?
I think the answer to that is that in the most recent contract, which there are two contracts actually at issue here. There's a July 2021 contract. In the most recent contract, there is a specific choice of law provision to Florida law. So
yeah, but that doesn't override. There are all sorts of agreements that contain a choice of law provision, but also contain an arbitral agreement. Your argument there would be that the choice of law provision overrides the arbitral choice, and all that means is that the arbitrator is going to apply Florida law in deciding the question. That doesn't seem to answer the question. Got anything else?
Okay, so with the FAA, I think the answer to the FAA issue is we don't get to the FAA unless we have a contract.
Yeah,
right?
But that's actually not what the FAA provides. The FAA provides that you may be right. The FAA may not apply if there's no contract. But that decision in the first instance about the existence of a contract belongs to the arbitrator, not to a court. That's what they're arguing, and I'm not sure I'm hearing your answer to that.
So yeah, the existence of the FAA says that the existence of the contract is in the hands of the arbitrator
in the first
itself.
instance is an arbitral decision. That's right.
Okay. No, I think that the issue was properly brought. I think the trial court has to decide what the agreement says, and I think that's where we are, right? And maybe the trial court has to say, is this an arbitral agreement from square one, from ground one? Is there an agreement? Does it meet the terms of agreement? Was there an offer? Was there an acceptance? That's a trial court level. That's a Florida law level thing to do.
But I'm not sure I'm not sure that's the law, unfortunately, for your position.
Do you think it's distinguished that they put other organizations as possibilities in that same arbitration agreement, that it wasn't just the AAA rule?
That's right. There were other. It was AAA, and there was
or
another.
Any other agreed arbitration organization.
That's right, and that's in the 2021 version.
Is that something that would affect that argument overall?
I think that's right, Your Honor. I think that it's sufficiently unclear. It's kind of like a catch-all. To your point, it is sufficiently unclear. That's correct.
Counsel, let me ask you same thing I asked opposing counsel about Baird. Why do we even need to address that question at all? Like, how does, in our role as the Supreme Court, typically to resolve conflicts, and if the District Court of Appeal typically is, how does it help the judiciary, or how does it help anything for us to reach the Baird question, as opposed to just answering the retroactivity question with respect to Stokes?
No, I would agree with that, Your Honor, which is I'm not seeing anything in Baird that rises to this level in terms of what, like you said, a conflict. So I would agree with that. I don't see anything that this court needs to address in terms of any kind of conflict as it relates to Baird.
You didn't argue that. I'm just curious. You didn't point that out in your response. That you just took them at, you took the other side's argument for what it was and responded to it, but you didn't address how this is consistent with our jurisdiction and conflict to reach out and deal with this completely separate question about notice.
No, and that's a good point. I think it as the respondent, we followed the suit in terms of what our adversary did, which is they took the opinion, and as counsel pointed out, the first DCA put it all out in one opinion, even though they divided the sections. So counsel proceeded to argue the whole thing, and we argued it as well.
Yeah, and just to be clear, there's prudential questions about what we should or shouldn't do as a matter of which issues we reach. But, do you have an argument that we don't have jurisdiction to address the Baird issue? I think the Constitution says once we have jurisdiction, we're reviewing the decision. Traditionally, the court has treated that as a matter then of discretion as to what other issues besides the conflict issue we take up. Is that wrong? Are you saying that we don't, even if we wanted to, that we couldn't reach the Baird issue?
We didn't say that in our briefs, and
okay.
We're not taking the position that there's no jurisdiction here. I think that it's more to the question that Your Honor posed, which is there a conflict that's out there?
On the Baird issue.
On the Baird issue, correct. And to me, of course.
And do we, quote unquote, need to address the Baird issue?
That's correct.
But you're not saying that we don't have jurisdiction to address the Baird issue?
No, we didn't raise that.
How many decisions are there in the first DCA opinion? Are there one or two? When the DCA says we affirm as to Baird, and then they move on to Roman numeral 2 and now address Stokes and all those arguments, is that one decision or two? When a DCA affirms as to one party and then addresses a disposition as to another party, is that one decision or two decisions?
Well, it's one opinion that takes two, what I would call them are issues. It takes two distinct issues and addresses them in one opinion. So it is one opinion, it's one ruling, it's one document, but to us they are distinct issues.
Can you shed any light on what your friend was saying about whether the cases were consolidated at trial?
And whether the cases were consolidated at trial? Can you remind me of that?
Were they consolidated by the trial court?
They were. There was no dispute as to the consolidation. All parties agreed to consolidate them.
Could you address a little bit sort of retroactivity issue before you run out of time. Is that, I think, kind of following up on what the Chief had asked the other side originally, why would we not just look at it as really not a retroactivity issue at all, but that we're just focused on what is a claim, what is any claim, when did that happen, which would be filing the lawsuit, and was that after the arbitration provision was in effect? Why would that not be a more straightforward way of looking at it?
So here's how I would see it, and I think one of the justices brought up the Clay opinion. And here's how I would see it here, and here's the distinction, and I think our case is more like Clay and some of the others that follow Clay, which is, this is even in Catherine Stanton's affidavit, there are two contracts here, and that's an important attribute to it. Two contracts based on transactions. So the issues that, what we allege Eglin did is that they violated their contract multiple times over multiple occasions. Each one of those events is a violation of contract. Sort of like in All South, where you have the purchasing of a tank, or the other case, the bags of rice case. These are transactions, right? So what the Seifert case looks at, and with retroactivity to your question, it's really two things. It's words and nexus. So what we get to is the words, the obtain word, and is it clear enough that what happened there is that the word obtain, for one, that phrase is entirely unnecessary. You don't need the phrase obtain. You can take your pen, scratch it out, and you can achieve a result that then gives life to this any language that they like. And the other thing is the word obtain in and of itself is a current or future tense word. If I were to walk into my kitchen and say,
I'm sorry, counsel, you know, I think we're straying into some of the areas where the arbitrator is supposed to be deciding these issues. When they joined, Ms. Baird and Ms. Stokes, when they joined the credit union, they signed a membership agreement, right? That membership agreement said that you will do amendments, you know, any amendments can, you know, this is the way we're going to communicate it to you. If you decide that you agree with these amendments, you will continue to use our services. If not, you know, you can do something else. Part of the amendment to that membership agreement was the addition of this arbitration agreement, right? Whether or not it was communicated sufficiently to Ms. Baird, I guess, is really the crux of the matter, because I think there is less of a credible argument that it wasn't communicated sufficiently to Ms. Stokes. In that arbitration agreement, it says claim. What is a claim? All claims are going to be resolved via arbitration, and claims are defined very broadly. Any claim, any dispute, regardless of the type of relief sought, to include the validity of the arbitration agreement, the enforceability of the arbitration agreement, the scope, does it apply retroactively or not, of the arbitration agreement. All of these things are going to be decided by the arbitrator, not by the court. Why isn't, you know, that sufficient to answer the questions of, you know, whether or not it should be applied retroactively or not, and what is the definition of any, and what is the definition of, you know, the other thing that you were talking about? Well, why isn't that language sufficient?
Well, I think that to answer your question, we'll get off the language thing, and then we'll talk about the retroactivity thing, which is what Seifert addressed, and then All South developed, which is these are different contracts. They're two different agreements. So, to your point, Your Honor, when they revised the contract in 2021, July of 2021, with very different provisions in it, the question is, I could see your question being square on for the July 2021 agreement, and thereafter. But the question that this court's ruling in Seifert, and then as developed by All South, is how far back does that reach? Does it reach all the transactions, all the different
It
contracts?
says any. Well, how has any been defined?
I'm sorry, any?
Any. Any claim, any disagreement between the parties, anything is supposed to, any claim or dispute, whether arising in law, equity, or otherwise, regardless of the type of relief sought.
Yes, that's right. And the question, that's the question that the courts have addressed in these prior cases, which is all the different contracts. Does when it says any claim that you obtain from us, which is a present or future looking linguistic, does it reach back and it reach back to all the transactions under all of the different contracts?
It also says regarding the scope. The scope is going to be also determined by the arbitrator. Scope, retroactively or just prospectively?
I'm sorry, you said it says scope. You're saying that's from, and you're getting that from the.
I'm getting
the
that language from the arbitration. Hang on, paragraph. So provisions in the arbitration agreement. Paragraph 5D. Claim. Claim means any claim or dispute, whether arising in law, equity, or otherwise, and regardless of the type of relief sought, involving your deposit account relationships, loans, including the validity, the enforceability, and scope of this arbitration provision, and any related account or loan documents, and any relationship that results from any of the foregoing. That's on page 304 of the record.
That's right. No, I understand what you're saying now. Our response to that would be that the language of the contract itself cannot override Florida law. So you can't.
But that is for the arbitrator. To Justice Curiel's point, isn't that for the arbitrator to apply Florida law, right? But in the first instance, where does it go? It's supposed to be going to the arbitrator.
No, and I think there's some murkiness there as well, which is, as Justice Grosshans pointed out, the provision is unclear as to exactly which arbitration act is going to apply here. There's a couple of different ones, so I think that's unclear. That's unclear. There's not a clear intent to be. For one, we get to whether or not there's an offer, but is there clear language or clear enough language here that says that these FAA provisions are powerful enough to override Florida law?
Could I ask you one quick question about the verb obtain, which you say can only sort of be construed as a current or future? I want to zero in on the current. In the context of an ongoing relationship, couldn't it be a defensible reading of the verb obtain to suggest almost like that you regularly obtain from us? Like everyone receiving this document already is an account holder. So when it refers to things you may obtain from us, I'm an account holder at a bank. I obtain from them credit even before I ask for more money. Just as a condition of my account agreement with the bank, you know, there's an extension of credit on my checking account, say. Why isn't that a permissible construction of the word obtain here? That indeed, present and future, but also ongoing in the context of this relationship?
I think that to me it seems, for one, these are lawyers drafting contracts, so to include that kind of language, it needs to be precise and it needs to be specific. And the way Eglin wants to point this out as being some kind of ongoing relationship and that sort of thing. It's to us, I don't think we see it as an ongoing fluid relationship.
Well, you don't dispute that either Stokes or Baird had an ongoing relationship with Eglin, right?
They had an account that consisted of a series of transactions. Now, whether or not that's the ongoing relationship.
I hope I have an ongoing relationship with my bank. I mean, I'd be really upset if I suddenly didn't have an ongoing relationship with my bank, wouldn't you?
Well, sometimes relationships with organizations, that you feel like they're relationships, and then things happen that you're starkly reminded that these are transactions. They're transactions, and they have specificity and a point of time, and that's why the contracts have the important language that they have, and that's why a lot of these I would surmise most of these transactions occurred under a contract that had very different language than the
Counsel,
July.
can I just ask you a quick question? I know that you're way over your time.
It says I got 152 left.
Well, no,
you're ready.
you're over time.
Oh, okay. I'm sorry.
Talk to me about Christian versus Comcast Corp. It's a First Circuit decision from 2006, and I believe it addresses kind of that retroactivity question. Talk to me about why that case is not applicable to some of the retroactivity arguments that are being made today.
You see the Christian versus
Christian versus Comcast.
And that was, I've read a lot of cases. You have to brush me up on the facts.
The First Circuit Court of Appeals, they said that the type of argument raised concerning retroactivity, right, in that case, it went to the argument about the scope of the agreement. And once you go into talking about the scope of the agreement, that is something that the arbitrator gets to decide, not a court.
In that case, I think that what I would ask in that case is, were the provisions that dictated which set of rules and which arbitrators clear enough? I think that would be the question that we're looking at here. Is the contract clear enough as to which set of rules these consumers agreed to abide by?
And you say the contract here was not clear enough?
I think there are some clarity issues in terms of the organization that the parties allegedly agreed to.
Okay, you can have 30 seconds to finish up. 30 seconds more. You're already 3.5 minutes over.
No, I think that these are, unless the court has any issues, I think we covered the big issues in terms of what I think the court is here to decide today. So,
okay,
thanks.
Thank you. Woody, you can add 1 minute to the rebuttal.
Thank you, Your Honor. You definitely have an ongoing relationship with your bank, and that's what's necessary. That for there to be this kind of amendment where in fact, the appellate court in this case said there was a contract to arbitrate between Stokes and Eglin. So it is a question of scope versus existence. And that's why AllSouth has no application, because that was an existence question, not a scope. That's why there's no support for what the First District did with respect to the requirement of adding retroactivity. This is a contract where all of our members joined us. Beard and Stokes joined us years ago, years before, and they had an ongoing relationship with us, and they agreed to be bound by any amendments thereafter. And they agreed to be bound by this particular agreement, at least Stokes did.
So the FAA issue, yeah. I know you made the argument about the FAA saying that you can't treat arbitration contracts differently from the way state law treats other contracts, and I understand your argument is Florida law and contract says any means any, blah, blah, blah. Does the FAA itself require that the rules of the AAA that say that the arbitrator decides whether there's an agreement on arbitration, the FAA itself says that those rules have to be looked at to decide this question?
Actually, it may, but I know that the AAA rules do say...
The AAA rules, no question.
Yeah.
Does the FAA itself say that states have to look to the AAA rules to decide whether it's a court or an arbitrator decides the question of whether there was an agreement to arbitrate in the first place?
No, what the FAA requires is that the same law apply to all contracts.
Okay.
And that nothing special be created just for
right. And you're saying that the first TCA ran afoul of that by saying that in the arbitration context in particular, we're going to take a narrower reading of any than we do in other areas of the law. We're going to require an affirmative statement of this applies to claims that already accrued or causes of action that already accrued beforehand. That's what you're saying the conflict with the FAA issue.
Right. It's adding a burden. It's adding the requirement that it not just say any, but that it also say, by the way, this also applies retroactively to all prior acts or claims.
Okay. All right. So you have 30 seconds if you want to finish up.
Yeah, I mean, the point is that there here, unlike in All South, there is a distinct ongoing relationship from the get-go. It has to be ongoing. It can't be intermittent. I mean, you have to be able to access your money 24 hours a day, 7 days a week. This isn't a distinct transaction like in All South. That contract was one and done back in 2010. And just mailing somebody, if we just mail, let me put it this way.
All right, we understand all state is different.
Yeah.
Do you have any other final words you want to say?
No, I just want to point out that this is something that these folks have agreed to, our members have agreed to, and there was already a finding that Stokes has agreed to arbitrate, and consequently it was just this question of the scope. The fact that we allow for a different arbitrator, that's the party's choice. That has nothing to do with clarity or whether there's a requirement to arbitrate. So I don't even understand the point of opposing counsel on that. But the bottom line is that the First District imposed an improper requirement of additional language that it does not require as to any other type of contract. That aspect needs to be reversed, and consequently Stokes at the very least needs to be found required to arbitrate this dispute.
Thank you very much. The court will be in recess for 10 minutes.
This honorable court is now in recess.
I'm sorry, I didn't catch your name. Sophia Gold said she was going to come here. Are you?
Yeah, we can switch.
Oh, okay. No, I'd see you, but I see what they do. I don't know. I'm surprised by just
Yeah.
lost most of our audience. Conversation. We were the argument seminar. Oh no, they're leaving before. It's the practicing. No, it's actually. Did he? Do whatever. Not sure.
Any thanks. Thank you. Keep you in line somehow.
The Supreme Court of Florida is now in session. Please be seated.
Okay, our last case today is Santiago Gonzalez versus State and versus Secretary Department of Corrections, numbers 2025-0450 and 2025-1282.
Right. May it please the court, I'm Elizabeth Spiaggi, and along with Ms. McCready, we represent Angel Santiago Gonzalez, the appellant. Today, I will only be addressing claims from the appeal of his denial of post-conviction relief. The first claim I'd like to address is the ineffective assistance of counsel for failure to inform the trial court of the medications that Mr. Sure.
At the
reception and medical center?
Yes, sir. This is
So everyone who is sentenced to state prison first goes to this reception center and stay there while they classify the prisoner and decide where to send them.
Yes, Your Honor, that is accurate. In Mr. Santiago's case, though, he was there for medical reasons.
Right.
He had been already in the Department of Corrections for some time before this incident. As you said, this is a prison murder that occurred within the Department of Corrections. After the incident, I think it was June 2016, Mr. Santiago is hospitalized for on and off for almost that entire month for near fatal self-harm that he did, well, self-harm that he inflicted on himself. And when apologies, the plea in this case, it takes place on August 15th. Between the time that he's hospitalized in June and the plea in mid-August, the Department of Corrections petitions for him to be involuntarily medicated. He's not complying with his necessary medications. They file a petition in the mental health court at this point he's being housed at Lake Correctional Institute, as they file a petition with the mental health court in Lake County asking that he be ordered to be involuntarily medicated due to being clinically incompetent to consent to treatment. This is granted, and the court agrees that they can medicate him with any of the listed psychotropic meds that they had submitted to the court. Prior to the plea, he is evaluated for competency. One of those evaluations occurs on July 5th. The other one occurs on July 16th. Those evaluators are not given records indicating the psychotropic meds that he's on. I believe one of the evaluators asks Mr. Santiago, and Mr. Santiago self-reports some of the medications he thinks he's taking. Pardon. And again, before that plea on August 15th, Mr. Santiago is again hospitalized, and at that point the hospital, when he's admitted, they do an inventory of the medications that he's on. Also, when he's eventually released, again, this was for a self-harm incident, so he is prescribed Percocet, which that prescription is active at the time of his plea. The involuntary medication order for the psychotropic meds is also in place at the time of his plea. Counsel did not have the records from the hospital, the records from the Department of Corrections, his medical records, or most importantly, this mental health case that is in effect at the time of the plea. In
the end, though, the question still is competency, and the trial judge is up there assessing competency, just in the courtroom. Counsel, whether he's, regardless of the amount of meds or the types of meds that he's on, still the question is he able to assist counsel, and does he understand what's going on? Those kinds of things. So how can you make the link between, okay, counsel didn't investigate or learn of all these other meds and bring that to the court's attention? Can you link that to the actual question of competency that was missed, or I guess the prejudice that would flow from this failure?
Right. So we're asserting that it wasn't a knowing and intelligent waiver of, when he's pleading guilty to the first-degree murder, that wasn't done knowing and intelligently. In dismissing this claim, the circuit court relied on trial counsel's testimony that they didn't remember seeing, if he had been acting in a way that concerned them, they would have brought it to the court's attention. That was their testimony at the evidentiary hearing. Mr. Chipperfield testified that he was listening not just to what Mr. Santiago was saying, but the way he was saying it, However, I think that that testimony is significantly undermined by Mr. Chipperfield's testimony that they were relying on a translator, that they were utilizing a translator to talk to Mr. Santiago Gonzalez about his plea. So when he's saying he's listening to the manner that he's speaking, I don't think that that's accurate if we know that he is in fact utilizing this translator. Yes.
Setting ineffective assistance aside just for one moment, what was the status of this argument on direct appeal, the underlying argument about the voluntariness and intelligence of the plea? Didn't we affirm? Didn't we pass upon this at the direct appeal?
So the issue that was raised on direct appeal was that the judge, sua sponte, should have revisited the issue of competency when they reached the penalty phase, and he sort of saw the full extent of Mr. Santiago Gonzalez's mental health issues. What we're saying here is that there was this involuntary medication order in place that the court wasn't aware of, and that the trial counsel should have been aware of and should have made the court aware of, so that in making that decision of whether he's competent, he's really looking at the full picture. So I would say that it's a different claim. The claim raised on direct appeal doesn't mention the involuntary medication order at all, or the mental health case.
It does ultimately conclude that the plea was free and voluntary, right?
It does, but
okay.
I do think...
I understand how that's different from
yes.
the ineffective assistance claim you're making now, but it seems like, am I wrong? Is it your argument that this is newly discovered evidence now, between the time of the direct appeal and the 3850, or I'm sorry, 51?
Yes, Your Honor. The mental health petition was the one that was in effect at the time of the plea, was discovered in the post-conviction investigation. The hospital.
I'm sorry. On the question of prejudice, so you have in this instance, you have the judge that actually took his plea, is familiar with the defendant, clearly familiar with the defendant, and the entire history and everything that went on. Then considering what post-conviction counsel is presenting to him, even if, like, let's say we did like one of these nunc-pro-tunc things and send it back, hey, can you consider now this evidence? Didn't he already do that? And so in the end, when you have this unusual situation where it's the same person, the same officer, judicial officer, that originally made the decisions, took the plea, and now is hearing this additional thing. Oh, and now there's this, there's involuntary med order. Where is the prejudice in all that? And can't the post-conviction judge say, okay, even if I heard all this and I knew that then, it wouldn't have made a difference. I still think he's competent.
I think the trouble with what the trial court did here is that they are relying on counsel still in the order dismissing the post-conviction motion. They're relying on trial counsel's assessment that if we had thought there was anything wrong with him the day of, we would have brought it to the court's attention. And I don't think that's competent substantial evidence. I don't think that the court is actually revisiting his own competency assessment, if that makes sense, right? He's relying again on trial counsel's representations, which are...
Well, plus the information now that you're bringing forth in the post-conviction motion about the meds and the order and those kinds of things. So the post-conviction judge, same judge,
yes,
has been involved all along, has now heard this, and so I'm having even if counsel should have brought it to the judge's attention earlier in the case, before sentencing or before the penalty phase, he's now hearing it in a post-conviction context and is still, rejected that as making a difference.
Yeah.
So, and what are we supposed to be doing on the prejudice side, even if we agree with you on the IAC aspect of it?
Yeah, I don't think you have to reach the prejudice when the decision on the ineffective assistance of counsel is so clearly undermined by the record. The other thing, I guess...
I think we do have to find prejudice, right? Even if we find it deficient?
I mean, not to remand and ask that the court readdress their order, right? I guess it depends what exactly we're asking.
So we have cases that saying on an ineffective assistance of counsel claim, we don't have to reach the prejudice prong.
No, oh, sorry, no, that's...
Sorry, I was just confused.
No. I guess what I was saying is that I don't think you have to get there in order to send it back for the court to reassess his order when the order sort of doesn't hold water as far as the IAC prong. The other issue, I mean, always looking back and doing this sort of retrospective on competency, comparing what the judge would do now compared to had the information been brought to his attention at the time, I think that's where the prejudice is. Had it been brought to his attention at the time, it would have been easy, right? He would have said, we're going to postpone this, do it another day when we can be assured.
That's not a given. I mean, that's a question.
Right.
Would it, because there's the premise underlying your argument on this front is that, okay, there are these meds, and the experts or the testimony says it could have affected someone, sort of the generic person could have affected someone's cognition or understanding, that kind of thing. Nothing that actually says that it affected this defendant specifically. And so you're still missing, I'm missing, where is that connection where the judge would automatically, oh yeah, that if I'd known that, maybe he should have then, the judge should have then said, oh, well, if knowing that and that it definitely affected the defendant at the time, then we need to do a new hearing. But that's not what's in the record on this.
No, I think that is the law, though. Once something is brought to the court's attention that weakens their belief in competency, they are supposed to have a full competency hearing and reevaluate that. And
right, but that was the aspect. That was the aspect that was addressed previously. I mean, so the lawyers dealing with him, the judge that had him in front of him at the time, they reached a conclusion about competency, and we affirmed that aspect of it. So, but you're saying that had the judge known these additional facts about the meds, it would have been a different outcome. But the meds themselves don't equal lack of competence.
No, that's certainly true, but I would also say that the evidence the judge is relying on, which is the attorney's assessment of Mr. Santiago, also doesn't equal competency, and the neuropharmacologist spoke to that and said, just because a person is sedated to this extent, being given lorazepam specifically to sedate, it's not necessarily going to manifest outwardly, right? But I guess I would just end with, if he's not competent to consent to treatment, it's hard to see how he's competent to make this other life-altering decision. I would ask that you remand for further proceedings.
Well, what about the other aspects of the appeal? That wasn't the only
No,
claim.
that was,
The reason I asked, so it's a related question.
Yeah.
So on the other IAC claims, for instance, so if you have, when your client asserts that his trial counsel was ineffective because they should have, like at the penalty phase, brought out the brain damage testimony, they should have investigated and presented that as additional mitigation. When you have a waiver of, there's no jury, and it's the same judge. It's the judge that's making the fact finding regarding the penalty phase. He's also hearing the post-conviction motion and its assertion that there's some defect in the proceeding, that the judge didn't know all the facts, and had he known the facts, then he wouldn't have ever rendered that judgment. And you have the judge hearing that evidence in the post-conviction hearing, and then concluding I sentenced him to death, but he didn't say it this way, but it's effectively what he's saying. I heard, I'm the one that sentenced him to death. I heard this additional stuff, and it doesn't make a difference. It doesn't prejudice. It's not going to mitigate his sentence. Why is that not enough? Like on the prejudice side, So if we can skip, like, can we just skip the first prong and go to the second prong and look at, okay, the post-conviction judge ruled that it didn't make a difference to him, and so there's no prejudice.
I think you have to look at what he's resting that ruling on and whether it's competent, substantial evidence that's supported by the record. And our position is that it's not.
All right.
Thank you.
Mr. Chief Justice, and may it please the court, I'm Jonathan Tannen, representing the state of Florida. On issue 2 in the initial brief, the claim regarding ineffective assistance for failure to bring to the trial court's attention medications affecting Mr. Santiago Gonzalez's competency, the post-conviction court correctly rejected this claim based on a finding of both no deficient performance and no prejudice. And under the Strickland standard, the defendant bears the burden to affirmatively establish both of those prongs of the Strickland test in order to obtain relief. As far as the deficient performance prong, the trial attorneys testified at the post-conviction evidentiary hearing that they were aware of the need to ensure that Mr. Santiago Gonzalez was competent to proceed. He was evaluated by 2 experts prior to the plea hearing. Dr. Meadows and Dr. Gianori, both competency experts, found that he was competent to proceed. He had no difficulties in communicating. He was oriented to time, place, and person. He was familiar with the facts of his case. He was familiar with the legal process, and his general fund of knowledge was good. Dr. Gianori gave him basic factual questions as far as if he was aware who the president was, if he was aware of who Martin Luther King Jr. was, if he could interpret a proverb, and he had no difficulties in any of these areas. Then at the competency hearing, or I'm sorry, at the change of plea hearing itself, the trial attorneys testified that, again, they were aware of the need to ensure his competency. They were observing him. They didn't see anything that, in their opinion, would have called his competency into question. Both the lead trial counsel, Mr. Chipperfield, and the trial court did fairly lengthy colloquies with him during the plea hearing. The trial court's colloquy is quoted in this court's direct appeal opinion, and Mr. Santiago Gonzalez answered all questions appropriately. It wasn't simply a situation of him saying yes to every single question that was being asked to him. He said yes to some questions. He said no to some questions. The trial attorney asked him if he understood what was being said. Mr. Santiago Gonzalez said perfectly. There was a point where the trial court mentioned that the plea could have Jimmy Rice consequences if he was pleading to a sexual offense. Mr. Santiago Gonzalez responded, "I don't have any sexual charges." So it's very clear from the actual colloquy that was done that he was competent to proceed, and that he did knowingly and intelligently plead guilty to the offense. Based on the testimony of the trial attorneys and everything that was done, the post-conviction court correctly found that there was no deficient performance, given that there was no outward indication that he was incompetent, and everything that was before the court showed that he was in fact competent. As far as the prejudice prong, the post-conviction court also correctly found that he failed to establish prejudice at the post-conviction hearing. That aspect of the claim relied on the post-conviction testimony of Dr. Lippman, but as the post-conviction court found in its order, Dr. Lippman was only able to testify to generic interactions of the drugs that Mr. Santiago Gonzalez was prescribed. He didn't have any knowledge of what drugs he was actually taking, which is important given that a lot of those drugs that were prescribed to him were prescribed on an as-needed basis only. And there was the expert agreed that he had no ability to say how the defendant was actually behaving on the day of the plea itself.
What kind of standard should the post-conviction judge, again, who's the same judge that sentenced the defendant, what standard should the judge apply on the prejudice prong? Should it be the objective standard? And I guess the objective standard would be what a reasonable probability would have made a difference to some abstract, unnamed judge, as opposed to the judge that actually made the decision in the first place.
I'm not sure that the Strickland standard changes depending on whether it was the same judge or not. The standard is whether there was a reasonable probability of a different outcome.
Well, right, but how does a judge who's sitting there hearing the evidence and may have to make a decision as to whether it would have made a difference to the outcome, and when it was the judge himself that decided the outcome? How does that work? It's an unusual situation. It doesn't happen very often, and it wasn't present. I mean, even though in Strickland it was similar circumstances where there wasn't a jury, but in Strickland it was a federal habeas that was on review, so obviously it was not the same judge. Here we have that unusual situation where the judge that made the decision as to the penalty is hearing the post-conviction motion. How does the judge separate that and do an objective analysis about whether it would have changed the outcome when it was the judge that decided the outcome?
Well, I think it does give additional weight to the denial of post-conviction relief here, given that the post-conviction judge, who was also the trial judge, wasn't simply relying on the cold transcript, but actually had Santiago Gonzalez in front of him for many hearings, and the penalty phase itself continuing into the post-conviction proceedings. So the judge had that opportunity to actually see Santiago Gonzalez in court on the day of the plea hearing.
I mean, it seems that the 3851 process uniquely works, or works in a uniquely effective way for this particular defendant, because the defendant has the opportunity. You know, it's based on a motion. They're trying to show ineffective assistance of counsel, but in the course of doing that, they're actually presenting the evidence to the judge that they say he should have had access to during the penalty phase. So he's in the hearing, he's actually hearing the things that weren't heard before, and then the judge is making a ruling as to whether it would have made a difference in this decision, right?
That's correct, Your Honor. I mean, the judge, at the end of the day, the judge is determining whether there would have been a reasonable probability of a different outcome had the information that was presented in post-conviction been presented at the time of the plea hearing itself. And based on his, not only the record itself, I mean, not just the cold transcript of the plea hearing and the record on appeal, but the fact that he actually saw Santiago Gonzalez in court on that day, he was entitled to say that there's no reasonable probability of a different outcome.
But I mean, you agree that for the Strickland mousetrap to work in general, we have to, and it requires mental discipline, I know, on the part of the trial judge applying it, especially if they were the ones who made the first decision. But I mean, it has to be based on some kind of constructed, objectively reasonable audience, right? I mean, otherwise we would be, you know, in this case it's the same judge, but if that's relevant here, then we should be asking in every case whether Judge Smith would have been persuaded. You know, is there a reasonable possibility that, you know what I'm saying? It just doesn't make sense. And the other, is there any, I mean, this is a federal standard that we're applying. Do you know that, is there any precedent where, you know, someone applying the federal test said, well, if it's the same judge, then the prejudice thing is really just asking, you know, what would you personally have done if you had heard all this?
I'm not familiar with any precedent that discusses that specific issue. It may be out there. Neither side has cited anything like that in the briefs. I'm not aware of anything in the record that discusses it. I think in this case, the judge did, based on the actual post-conviction order, treat it as an objective standard. And even if he hadn't, this court, of course, affirms on any basis supported in the record. Here, the record amply supports a ruling, whether it was the same judge or not, that Santiago Gonzalez was competent on the day of the plea hearing, and that there's no reasonable possibility of a different outcome based on what was presented in the post-conviction proceedings. And again, regardless of whether it's the same judge, the post-conviction judge is entitled to find the post-conviction expert not credible, or rather that the testimony would not, that was given, would not have been credible evidence to change, that results in a reasonable possibility of a different outcome, on the question of whether Mr. Santiago Gonzalez was competent. I would just point out that as far as the involuntary treatment orders, the specific order that was entered on July 1st, 2016 wasn't in the record on appeal on direct appeal, but there were numerous other orders that were almost identical that were in the record, and this court reviewed those orders and found that they didn't raise any bona fide doubt as to Mr. Santiago Gonzalez's competency. And in this case, the order finding him of involuntary commitment was entered on July 1st, 2016. He was then evaluated by Dr. Jainori on July 6th, 2016, and by Dr. Meadows on July 15th, 2016, and both of those experts found him competent to proceed. So our position is that the post-conviction court correctly found, based on the evidence presented at the evidentiary hearing, that counsel was not deficient and there was no prejudice. Just to quickly address the brain damage claim, the post-conviction court, again, found no credible evidence that would have changed the outcome as far as the penalty phase. At the post-conviction hearing, the defense presented the testimony of Dr. Wu as an expert in neurological imaging. He testified to various conditions that he thought were consistent with the MRI and PET scans. The state presented in response the testimony of Dr. Coyne that Santiago Gonzalez did not meet the diagnostic criteria for any of those conditions. He didn't believe the actual imaging supported that testimony. And there was nothing, and the post-conviction judge found that there was nothing presented at the post-conviction hearing that would have called into question its ruling in the sentencing order that Santiago Gonzalez did not meet the statutory mental health mitigators of extreme mental or emotional disturbance.
Well, that sounds like it's, going back to my question, that sounds like it's combining both prongs again. So if the question is, should counsel have investigated and talked to these experts and tried to present that at the penalty phase, why does it matter if there's a dispute? You know, okay, there's an opposing expert that would rebut that, but wouldn't that be for the, I don't know, the quote fact finder, which happens to be this particular judge?
Well, I was speaking specifically to the prejudice prong of the Strickland standard,
Sure.
And the post-conviction judge sitting as the finder of fact at the evidentiary hearing is entitled to find that there is no credible evidence to support the defendant's claim. On the deficient performance prong, the post-conviction court also...
Which is no reasonable probability of affecting the outcome.
Correct.
Right?
That's correct, Your Honor.
Which is the sentence of death, is the outcome.
Exactly. A reasonable probability that it would have resulted in a different sentence. On the deficient performance prong, the trial attorneys did investigate this issue. They hired Dr. Quiroga, who was an expert in neuropsychology, to investigate Mr. Santiago Gonzalez's mental functioning. She ended up testifying at the penalty phase that he had cognitive defects resulting from his childhood drug use. But according to the trial attorneys, she never told them that any kind of imaging was necessary for her to render her opinion, or that it was something that would have been useful. Mr. Goldman, who was one of the attorneys, testified that that was something they were interested in. They did discuss that with Dr. Quiroga, but she never indicated that that was something that she needed or wanted. And given that they didn't have an expert who was telling them that that would have been useful information or a useful line of investigation to pursue, there was no deficient performance in failing to follow up on that, especially given the extraordinary volume of mitigation evidence that was actually presented at the post-conviction hearing. If the court has no further questions, I would simply request that the order denying post-conviction relief be affirmed.
Thank you very much.
Thank you, Your Honors.
Hello again. I did want to take issue with the state's characterization of the colloquy. I don't think it lends to establishing that Mr. Santiago Gonzalez was competent. There's one question, I think it's one of the first ones Mr. Chipperfield asks, and he says, is it true that you're not on pain medication? And Mr. Santiago says, no. And then Mr. Chipperfield says, let me rephrase that question, and he rephrases it so that basically no is the correct answer. Then as the judge is going through his colloquy, there's a question where Mr. Santiago is answering before the question is even complete, which to me does suggest that it's just a rote answering of these questions without taking in and comprehending. So I would take issue with the state's characterization of those colloquies as showing that he's competent. As for the brain damage, I think that what was really lacking from the presentation at the trial level were the physical evidence, the physical scans corroborating what Dr. Quiroga was pointing to, the cognitive disorder. And Dr. Quiroga did testify that she had reviewed records indicating organic brain damage. Part of the problem here is that Dr. Quiroga is a neuropsychologist. She can't order scans. She's not qualified to prescribe MRI scans for them to review. So regardless,
is she qualified to say, hey, based on everything I've seen, we should try to get someone to do scans?
I mean, it would be helpful, but she never said that. She also never told them, don't get scans. It won't be helpful. Mr. Goldman and Mr. Chipperfield had contemplated retaining a neurologist to order scans so that they could further pursue that. The case was ultimately taken over by a different public defender. Mr. Chipperfield left the case, and I don't think that they made a strategic decision upon which we can rely as far as getting the scans or not getting the scans. It more appears that it sort of fell between the cracks. If there are no further questions, I'll rest on the briefs.
Thank you very much. We're adjourned.
All right.